defense of Konstantin Borisovich Koraev's thesis for the doctoral degree of legal sciences on specialty 120003, civil law, business law, family law, private international law, on the topic Insolvancy, New Institute for the Legal Regulation on Financial Recovery and Bankruptcy. According to the order of St. Petersburg State University from the 13th of June 2019, number 6575/1, me, Makarova Olga Alexandrovna, Doctor of Law, Associate Professor of the Department of Business Law of St. Petersburg State University, was appointed the chairman of this council. And also allow me to introduce my fellow board members. Petrov Dmitry Anatolyevich, Doctor of Law, Associate Professor of the Department of Business Law. Koraeva Luisa Timbalatovna, Doctor of Law, Doska Koshian Mining and Metallurgical Institute. Kurbatov Alexey Yanovich, Doctor of Law, National Research University, High School of Economics. Kamenkov Viktor Sergeyevich, Doctor of Law, Belarusian State University, Belarusia. In the remote mode, Ilyukina Marina Viktorovna should work, Doctor of Law, Russian Presidential Academy of National Economy and Public Administration. The connection with her is being installed. According to the federal law, from the 23rd of August 1996, number 127, Federal Law on Science and State Scientific and Technical Policy, St. Petersburg State University has the right to independently award academic degrees. The corresponding order on the procedure for awarding academic degrees at St. Petersburg State University, on the basis of which we conduct our meeting of the Council, was issued on the 1st of September 2016, number 6821/1. In accordance with this order, the meeting of the Dissertation Council is considered eligible if at least 2/3 of the approved membership of the Dissertational Council takes part in its work, but not less than 4 persons. There are 6 members of the Council. All of them are present, including those this one. There won't be a remote connection, remote interactive mode due to technical problems. We have got quorum. According to technical reasons, interactive mode is not working today. And the procedure of today's meeting of the Dissertation Board, with a total duration of no more than 2 hours, is the following. The chairman's summary report on the main content of the documents submitted by the candidate and their compliance with the established requirements. Answers to possible questions, 5 minutes. Brief report of the candidate for the degree reflecting the main points of his research, 15 minutes. Questions to the candidate strictly according to his report, no more than 2 minutes for one question. Responses of the candidate. The speeches of all the members of the thesis council by turns, with reviews, with the statement of their positions, with questions and suggestions to the candidate. No more than 10 minutes for the speaker. The speech of the chairman with his review. The answers of the candidate for the degree to the questions and remarks of the members of the Dissertation Council. No more than 15 minutes. Open discussion, speeches at the request of those present at the defense of the thesis of persons with a brief presentations of their positions and with specific questions and proposals to the candidate strictly on the topic of the research. No more than 5 minutes for each applicant. All interested persons are requested to register in the registration sheet and before submitting their speech fully introduce themselves. Final answers of the applicant to the questions asked, no more than 5 minutes. The speech of the scientific supervisor, no more than 3 minutes. A 5-minute break before an open vote in order to make a conclusion on the issue of awarding or not awarding the academic degree. An open individual voting, counting of votes by the chairman with entering the results of the in the minutes of the meeting, decision on awarding or not awarding the academic degree, the final word of the applicant, no more than 2 minutes. Before switching to the realization of the meeting's rules of the procedure, I remind you to switch off your mobile phones. Thank you for attention. I also inform you that an audio and video recording of our meeting is being conducted, as well as live broadcast on the website of St. Petersburg State University, and simultaneous interpretation of speeches from Russian into English or from English into Russian is also provided. Let me start the procedure of the meeting. Chairman summary report: the dissertation of Koraev Konstantin Borisovich for doctoral degree of legal sciences on specialty 120003 on the topic Insolvancy, New Institute for the Legal Regulation of Financial Recovery and Bankruptcy, was accepted by the order of Scientific Secretary from the 13th of June 2019, number 6574/1. The thesis council was approved by the order number 6575/1, and I have also introduced my fellow board members, the candidates submitting the following documents to the Scientific Secretary: an application form addressed to the rector, Professor Koraev, about the acceptance for the consideration and defense, issued a list of publications containing 50 works outlining the main scientific results, including 30 articles in peer-reviewed journals from the list of the Ministry of Education and Science, the Diploma of Candidate of Sciences, certifying that by the decision of the Scientific Council of St. Petersburg Scientific Council, Mr. Koraev received the candidate degree of legal sciences. The thesis is done in Russian and English, both in paper-based version as a manuscript and in the electronic form. The thesis is designed in accordance with the requirements of national state standard. The thesis is printed on a multiplier with the indication of the output date in accordance with national state standard. All the listed documents comply with paragraph 12 of section 3, presentation and defense of dissertations, procedure for awarding academic degrees at St. Petersburg State University. And now, brief report of the candidate. I remind you, Konstantin Borisovich, that you have got 15 minutes. Please have the floor. Good afternoon, distinguished chairman, distinguished board members, distinguished guests. Let me bring to your attention the dissertation on the topic Insolvency, New Institution of Legal Regulation of Financial Recovery and Insolvency, Bankruptcy. The relevance of the topic of the dissertation research is due to the fact that until the mid-19th century, the subject of bankruptcy was the insolvency relationship that arose after the initiation of bankruptcy proceedings, and by the methods of bankruptcy law, the judicial termination of insolvent debtor. After this time, in the competition law of the overwhelming number of states, including Russia, there appeared rules, the methods of which became the opposite method of legal regulation. The subject of legal regulation of these norms was not only the relations arising after the initiation of bankruptcy proceeding, but also the relations arising prior to the initiation of bankruptcy proceedings. Such norms came to be called the norms of financial recovery. This conceptual approach is contradictory one. It seems that norms based on different methods of legal regulations cannot form a simple institute of law, since when differentiating institutions and some institutions, the regulatory methods plays a decisive role. In this regard, it is relevant scientific study of the legal nature of the rules of financial recovery and their relationship with the traditional rules on competition law. Despite the opposite of the methods of legal regulations used and the specifics of the subject of legal regulation, the norms of financial recovery and traditional rules of competition law govern the same type of public relations. A retrospective study of the content of the concept of insolvency made it possible for the first time in the science to indicate that it is incorrect to consider the insolvency phenomenon only as one of the criteria for insolvency. On the contrary, as a result of the study, it is concluded that insolvency is a process in the dynamics of which it is necessary to distinguish three stages: relative insolvency, absolute insolvency, insolvency when there are external signs of bankruptcy and they are established by the court. Under these circumstances, not insolvency is an external manifestation of insolvency. Insolvency represents a certain stage in the dynamics of insolvency. It is believed that reducing insolvency only to the insolvency criterion led to the fact that in science and law they did not attach importance to relative and absolute insolvency, and the current norms of financial recovery got their origin and development within the framework of traditional competition law, the subject of which was bankruptcy relations. The development of these standards has led to their becoming complete with the rules on the liquidation of the debtor. In scientific terms, this has created the problem of direction of competition law. What should it be, continuing or procrediting? As a result of the dissertation research, it is concluded for the first time that the present stage of development of competition law norms on restoring the insolvency of a debtor have reached such a stage of maturity when it is necessary to talk about their independence in relation to traditional competition law in the bowels of which they appeared. This means that the norms of financial recovery and the traditional norms of competition law, having different methods of legal regulation in the modern system of law, are substitutes of law, which should be called as the Sub-Institute of Financial Recovery and Sub-Institute of Competition Law. It should be called the Institution of Insolvency. The conclusion made in the scientific plan allows us to argue that it is more correct to raise the question not about what direction the Sub-Institute of Competition Law should be, but at what stage of insolvency should the priority be given to the norms of the Sub-Institute for Financial Recovery, and what stage should it be given priority to the norms of Sub-Institute of Competitive Rights. The experience of applying the norms of the bankruptcy law has led to the conclusion that with the legal regulation of insolvency at the insolvency stage, priority should be given to the norms of the Sub-Institution of Competition Law. You should also pay attention to the fact that changes in the structure of the rules governing insolvency relations should be reflected in the legislative system, since the development of the legal system determines the corresponding transformation of the legal system. What should these changes be expressed? Firstly, since the development of the traditional rules of competition law led to the formation of a complex institution of the law, the subject of regulation of which is not limited to insolvency regulation, the current name of the legal act on insolvency does not correspond to the nature of the norms it contains. It should be also noted here that an attempt to rename the law was undertaken by the Ministry of Economic Development of the Russian Federation. Secondly, the legal act fixing the norms of the institution of insolvency should consist of such main sections as general provisions which should contain the general rules of the insolvency institution, financial recovery of the debtor, insolvency of the debtor, features of financial recovery and bankruptcy of certain categories of debtors. The analysis of the economic nature of the restoration of solvency allowed us to conclude that the subject of the sub-institution of financial recovery should be differentiated depending on whether the insolvency is entrepreneurial or consumer. In case of entrepreneurial insolvency, the subject of financial recovery sub-institute is the relationship arising from overcoming the state of inefficiency or of the debtor's capital in the absence of trust on the part of creditors. In other words, the legal regulations of relation to restore entrepreneurial solvency should be aimed at protecting the debtor's property from claims of creditors during the implementation of measures to restore solvency. In the context of consumer insolvency, the subject of a financial recovery sub-institution is a relation arising from the prevention of the appearance or growth of an overdue debt of a citizen during a period of a significant reduction in his wages in the absence of trust from his creditors. In other words, the legal regulation of relations to restore consumer solvency should be aimed at preventing the emergence of increasing arrears of a citizen during the period of a significant reduction of his salary. A feature of citizens as subjects of civil legal relations is that their main activity is not based on the consumption of public credit. The indicated circumstance, as a general rule, should exclude the possibility of applying to the citizens the institution of insolvency that arose on the basis of a loan. However, the aforementioned does not mean that insolvency standards cannot be applied to citizens. If the emergence of the institution of insolvency was associated with the need to protect public loan, then its application to citizens, it seems, is impossible only when these entities are consumers of public credit, which needs protection from insolvent persons. Under these circumstances, the dissertation concludes that the institution of insolvency should not apply to all these citizens, but only to those who are unable to fulfill monetary obligations arising from loan arrangements or loan agreements concluded with credit institutions. The basis of the legal regulations of the restoration of consumer insolvency is the concept of debt restructuring, the application of which seems to be ineffective, since it does not correspond with the nature of regulated relations. This is manifested in the fact that, on the one hand, the application of the concept of debt restructuring requires the emergence of overdue debt, while actual relations to restore solvency require that a citizen's overdue debt don't grow during the period of significant reduction in his salary. On the other hand, a prerequisite for debt restructuring is the existence of a source of income for debtor consumer, which is directly indicated in the current legislation in paragraph 1 of Article 213.13 of the Bankruptcy law. In this regard, as a result of the study, it is concluded that the concept of debt prevention should be the basis of legal regulation of the restoration of consumer solvency, the main idea of which is to prevent the occurrence of overdue debt or increase its size during the period of lack of income from the debtor consumer. It is important to note here that on the 31st of July 2019, the amendments to the federal law on consumer loan came into force, which regulates the use of credit holidays and do it on qualitatively different principles that were not previously used in the legislation, and which are based on the concept of private debt citizens. Thank you for your attention. Konstantin Borisovich, thank you very much. Dear colleagues, board members, your questions to the candidate. I have got one question. I would like to find out about your point of view. In further laws about bankruptcy in the Russian Federation and in former Soviet Republic, maybe pre-court recovery is useful. There is a conclusion in my thesis. I pointed out on this fact in my speech. Absolute insolvency and relevant insolvency, these are stages which exist beyond judicial process, and such financial recovery norms should regulate insolvency relationships at this stage. And we conclude that the measures on the recovery of insolvency should be beyond the court. At the same time, here we say in case the stages of relevant and absolute insolvency, it was not possible to realize this message, and with further initiating of case about bankruptcy, but it should be an additional instrument, but not main instrument. Any other questions? Konstantin Borisovich, as for your concept about the prevention of the debt, in my opinion, the main counter-arguments could be problems with the protection of the creditors' rights. We don't allow the increase of the debt, but how can we protect creditors' rights? As for the creditors' rights, I explain it in my thesis. Here, making this decision, we should get rid of something. The mechanism of prevention of debt should not exclude some measures. A minimal term of delay is possible, and a possibility to give further payments. And my answer to this question, it is not, these are not theoretical reflections how to protect creditors' rights. It is the reality today. From the 31st of July 2019, the law was supplemented by the Article 6.1. It gives the right to stop the commitments up to 6 months, and this minimal term comes into power where delay is not impossible. Are there any other questions? And those who are present, thank you. And in the remote mode, we have got Marina Viktorovna Telukina, Doctor of Law, Russian Presidential Academy of National Economy and Public Administration. Marina Viktorovna, can you hear us well? Please take an active part in the work of our dissertation council. And now we turn to the other part, the reviews, including external reviews. There were external reviews from Mr. Papandopoulos, Semiusov, and Pavel Conte. All the reviews, according to point 19, on awarding degrees at St. Petersburg State University, they were placed at the official website of St. Petersburg State University. And please allow me to read out briefly these reviews, highlighting the remarks. The review of Professor, Doctor of Law, Head of the Department of Business Law, Vladimir Fedorovich Papandopoulos. There is topicality, relevance in this work. There is a conclusion about main provisions and recommendations on the improvement of the legislation system. And on the whole, the Papandopoula points out that it is a completed independent work. All the conclusions are true. As a remarks, there are no remarks. Vladimir Fedorovich points out that the thesis that our candidate deserves the degree, and the work responds to all the requirements. As for the review of the acting law, the lawyer from the Ufund company, Conte Pavel Viktorovich, there is one remark. It's not a remark. This is the reflection of the Conte about the concept of debt prevention, and in this review there is a new reference to a new federal law. All the provisions in this study are acknowledged in legal terms, and the thesis conforms with the requirements, and the candidate deserves the doctoral degree. The review of the Doctor of Law, Professor of the State University of Baikal, Valery Alexandrovich Semyusov. It is a positive review, complex, holistic approach to the research. There is one remark about the suggestion about the set of legal norms about insolvency, provision for the defense. This institute is of complex character and serves as a balance between state norms and legal norms, and should be viewed and the Institute of Business Law. It is of private character and does not degrade the high quality of the study. The work is completed and solves important methodological problems, conforms with all the necessary requirements, and the candidate deserves the doctoral degree. After these external reviews, I have to give the floor to our board members, and the first will be Petrov Dmitry Anatolievich. Please have the floor. Thank you very much. It was very interesting for me to read the thesis of Konstantin Borisovich, and as a result, I want to highlight that the topic of the work is very relevant, and pay attention to the practice of arbitrary courts, and we will see that a lot of cases about bankruptcy are being considered in the system of arbitrary, in the courts of arbitration, and the mechanism of legal regulation were improved. And as for subsidiary liability, it leads to the fact that the Institute of Bankruptcy is becoming more and more actual, and the topics which are connected with the research. But the work of our candidate tries to go separate from standard stereotypes of the study of bankruptcy topics. He focused on the insolvency, scientific provisions, recommendations which are formulated in the thesis. They are reasoned and proved by the analysis of normative acts. A lot of literature on the topic was analyzed. The novelty of scientific provisions are also objective, and they are reflected in the text of the thesis, and they are proved by the complex analysis of the problems, legal norms, and the subject of the research. On the whole, evaluating the work positively, I would like to draw your attention to some questions. First of all, in provision number 2, the author offers to understand insolvency as an inability to complete some requirements. In provision number 3, the author considers insolvency as a process and highlights in its dynamics 3 stages. The earliest is relevant insolvency comes when the term is expired and it is not beyond the certain period. The next stage, absolute insolvency, when the period of, but it is not, this fact is not stated by the Court of Arbitration as a orienting point for the period of delay. The third, and this law enforcement practice and doctrinal researchers for the aims about subsidiary liability operates the concept of objective bankruptcy as a certain critical moment where the debtor became unable to meet the requirements of creditors, including compulsory payments. This concept, objective bankruptcy, involves the situation of no technical by factual default, the increase, in other words, unfavorable financial position of the debtor is not always qualified as the objective bankruptcy, and as a consequence insolvency. How do these categories correlate? Our situation identified objective bankruptcy. To what extent this term is, this concept is of universal character in the context of the problems which are discussed. Provision 3 for the defense. The author in the system of modern Russian civil law offers to highlight the Institute of Insolvency, consisting of 2 sub-institutes, financial revival and competition law. The aim of this institute is the elimination of this insolvent debtor. In this respect, the position of the author should be explained. First of all, the fate of the supervision procedure is not clear, and a reference on page 159, we can think that the author does not refer the supervising procedure to the Sub-Institute of Financial Revival. Secondly, in some cases, when the court considers bankruptcy case, there is the procedure of competition. For for example, construction company bankruptcy, creditor company bankruptcy. Such simplification of competitor facts will be reasoned from the position of non-application. And the last question. In provisions 7 and 8 for the defense under regulating of insolvency of citizens who are not entrepreneurs, the institute of bankruptcy should be applied not to every citizen, only to those who can't comply with financial obligations. Here the author should explain why only credit relationships are included into this sphere, why the institute of insolvency can't be applied in other spheres. The contracts which are not connected with crediting. In our opinion, the thesis is a completed, separate and scientific study in which some theoretical provisions are elaborated. They can be qualified as scientific successful provisions. The thesis itself conforms with the main requirements stated by the order of St. Petersburg State University from the 1st of September 2016, number 6821/1, procedure on awarding academic degrees at St. Petersburg State University, and our candidate deserves the degree of the Doctor of Law on specialty 120003. Thank you for your attention. Dmitry Anatolievich, thank you very much. And now I give the floor to Koraeva Luisa Timbalatovna, North Caucasian Mining and Metallurgical Institute. Dear colleagues, all those who are present today, before my review, I would like to express my gratitude to St. Petersburg State University and authorized dissertation council for the opportunity given to me to take part in its work. And I hope that we will have fruitful work in the near future, and I will take active part in the work of this council and the study of our candidate. The thesis of our candidate of Koraev Konstantin Borisovich is relevant. Aims and tasks of this work are the goal of the research is to receive new scientific knowledge about modern state of competitive law, on the basis of which new norms of law appeared, the norms of financial revival. The work comprises 308 pages, including the literary sources, and 10 chapters and 12 paragraphs. At the end of each paragraph, there are conclusions. Each chapter has a conclusion. Each chapter has an introduction, main context, conclusion, reference list, and conclusions and recommendations are formulated in the thesis, and in our opinion, they are reasoned. It is proved by the analysis of scientific literature, special literature, and law enforcement practice. I would like to highlight that the novelty of the research and the provisions, they objectively exist, and they are reflected in the text of the thesis, and they are proved in the complex analysis of the problems, normative legal acts on the subject of the research, and the application, approbation, scientific and methodological apparatus. In the introduction, the actuality is explained, the extent of scientific development is shown, aims and tasks are formulated, the object of subject of the research as well. The methodology is explained, theoretical and normative and empirical basis of the research are characterized, scientific novelty is formulated, and the provisions for the defense are demonstrated, clearly demonstrated. Theoretical and practical significance of work is also felt. There is information about the fact that this research is reasonable. The facts of approbation are shown, and I would like to briefly dwell upon these moments. In section 1, the problematics of the topic is studied. Literature review is offered, on the basis of which the author conducts his research. The characteristics of the subjects of the Institute of Insolvency is shown in section 3. In section 4, the analysis of law and regulation is shown, liquidation and insolvency. I would like to stress that as a result of the research, in our opinion, the results received approbation. It is necessary to support our candidate that material legal relationships of insolvency, they should be done on the relationships on financial revival, and the relationships on financial revival preserve financial obligations within the frames of which the protection of rights occurs, and so on. Legal relationships of insolvency, these are financial obligation with active multiplicity of the parties, within the frames of which the creditors claim, and the relationships of insolvency are of property character and requires the application of the methods of legal equality of the parties, and it proves that these relationships are of civil legal character, and the Institute of Insolvency and the Institute of Civil Law, this the conclusion of the candidate about the necessity to alter the norms of regulating relationships in terms of insolvency, and they should be reflected in the legal legislation system. For example, The development of the legal system is stipulated by the improvement of the system of legislation created by legislators. Then I would like to support the argumentation of our candidate that acting regulation of the procedure of the restructuring of debts of the citizen has a lot of drawbacks, serious drawbacks, and these drawbacks don't allow to many citizens to use this procedure to create the procedure of the insolvency. But these drawbacks are due to the fact that the legislator did not take into account that the most part of debts of the citizens comes from bank loans, which are of specific character and require new, different regulation in comparison to non-bank debts. I would like to emphasize that the author proves that in case of restoration of business insolvency, there is risk of which can exclude the opportunity of creating his insolvency. In this case, there is a necessity in legal protection of the debtor's property. I would like to emphasize that the advantage of the research is the outlining of main moments in acting legislation and the offers how to alter existing approaches concerning consumer bankruptcy, regulating the relationships on competitive mass and others. Also, I would like to emphasize that most important scientific searches of our candidates are in the system of modern civil law. As I have already, as my colleagues have already mentioned, the Institute of Insolvency rather than Institute of Competitive Law, which consists of two sub-institutes, Financial Revival and Competitive Law. The subject of sub-Institute of Financial Recovery should be differentiated due to the fact whether insolvency is business or consumer one. It is very important to emphasize that while regulating insolvency of the citizens who are not entrepreneurs, the Institute of Insolvency should be applied not to every citizen but only to those who are not able to fulfill financial obligations. Then the basis of legal regulation the concept of prevention of the debt is of high importance, the main idea of which is gets down to the prevention of delayed debt and its increasing within the period of the absence of incomes of the consumer, and its use makes possible to apply a legal mechanism when serious reduction of its salary occur, and along with that, the loss of the ability of its citizens to pay. And the conclusion includes the main conclusions of the author on these problematics. The work is written in a clear language. Author's reflections are very persuasive and logical. Many facts are used. Conclusions which are formulated, they are scientifically reasoned. As for the questions and provisions, we consider the following. The first one: what is the correlation of the author's offers of the law number 127 about the bankruptcy from the 3rd of July 2019, and how are these legislation alterations are taken into account, and also why the liabilities, bans and limitations of the debtors are not reflected in the thesis. And also parties who take care about the debtor. Along with that, all these questions on the whole don't influence the positive impression from the work and don't diminish its scientific value as well as theoretical and practical value. The author's publication reflects the main content of the thesis. I would like to focus on the correlation of the thesis to the stated criteria. The thesis is a completed, independent, qualified research containing the solution of the tasks and the thesis of Koraev Konstantin Borisovich on the topic Insolvancy, New Institute for the Legal Regulation on Financial Recovery and Bankruptcy, for the degree of the Doctor of Legal Sciences on specialty 120003, Civil Law, Business Law, Family Law, Private International Law, conforms with the main requirements stated by the order from the 1st of September 2016, number 6821/1, on procedure of awarding academic degrees at St. Petersburg State University. And our candidate, Koraev Konstantin Borisovich, deserves the degree of the Doctor of Legal Sciences on specialty 120003, Civil Law, Business Law, Family Law, Private International Law, without doubt. That's all for now. I have finished. Thank you very much for your attention. Luisa Timbalatovna, thank you very much. And now I would like to give the floor to Kurbatov Alexei Yanovich, Doctor of Law, High School of Economics. I positively appreciate the thesis of Koraev Nikolai Borisovich and its topicality. The tasks are of high practical value for the legislation on insolvency and bankruptcy. Also, I think that our candidate demonstrated artistic approach and independence of his mind. The provisions for the defense are conceptually new. They deserve the attention and development, but along with that, as any scientific work which is dedicated to a difficult topic, the thesis is not free of some questions. There are 5 questions to the candidate. The first one, our candidate uses the term insolvency. What place is occupied by the bankruptcy? Is it a synonym to insolvency? Provision number 3. Question number 2. The candidate offers to differentiate of the Sub-Institute of Financial Recovery. Provision number 5. There is a question. How the difference between business and consumer insolvency differ from each other. Number 3. Our candidates think that in competitive area, the property of a debtor is taken away. And how can you explain from the point of view of this approach that the property right is preserved for the debtor, and here we are talking about the forced elimination of the property. Number 4, according to your opinion, the immanent feature of the institute with the ability stops. This is the text of the thesis, and if the limitation of this final, in other cases we deal with external features of the limitation of the inability, and it is not enough to call it the institute of the finishing of inability. In this respect, the limitation of the citizen's right hurts his own interests. It is the essence of legal regulations. It is stipulated by the Constitution of the Russian Federation. Question 5. Our candidate offers to apply the Institute of Insolvency quotation not to all citizens but to those who are unable to pay on the basis of credit contracts or debtor contracts. This is provision 7 and 9 for the defense. And how can these problems with other debts be prevented? For example, communal payments, and so on. These 5 questions don't spoil the positive impression from the thesis. And in this respect, the thesis of Koraev Konstantin Borisovich is a scientific qualified work where the scientific problem is successfully solved. The thesis conforms with the main requirements stated at St. Petersburg State University, and our candidate Koraev Konstantin Borisovich deserves the candidate degree of the Doctor of Legal Sciences on specialty 120003. Thank you very much. And now Kamenkov Viktor Sergeyevich, Doctor of Law, Belarusian State University, distinguished chairman, distinguished board members. I would like to express my gratitude for the invitation to take part in the work of this dissertation board. I see greater sense in that. I know that you also study various processes in former Soviet republics. For example, on the example of the former Soviet Republic, for example, only now high governmental commissions were created, and the complement of St. Petersburg State University is the following. You are ahead of these governmental commissions and made the first step in order to have compromise with these problems, and it allows to unify various things, legal education, legal science, and so on. And sorry, I touched upon not only dissertational problems. I submitted my written review into dissertation board. The typicality, its correlation with all the requirements, approbation, the extent of novelty, and I would like to allow me not to repeat it, as my remarks are positive, and it's no use reading them out. And as for the remarks and questions, I would like to focus on them, but these are not those remarks which negatively influence the impression from the study. Separate questions which are not clear for me, they are the following. First of all, what is your attitude to the fact that many authors who study these problems call it complex institute? We understand that there are a lot of interdisciplinary questions. Whether it is only the Institute of Civil Law, it is questionable moment. Then, on page 254 of the thesis, there is only the information about drawbacks of acting legislation concerning the debts of the citizens, and I would like to know what you offer. This is a very interesting topic, not only for the Russian Federation or Belarus, but for many other countries. There is only a conclusion about the insolvency of the debtor, and he offers to eliminate the norms. We have got similar norms. I would like to hear what about the acting manager. And in my written review, I pointed out that our candidate deserves the doctoral degree, and his thesis conforms with the requirements. Thank you very much for the attention. And now I want to give the floor to the Doctor of Law, to Telukina Marina Viktorovna. Can you hear us? I can hear you. Please have the floor. Can you hear me well? Thank you very much for the opportunity given to me to take part in the meeting in the dissertational board, for the opportunity to work with you in the remote interactive mode. I will start my speech concerning the Insolvency New Institute for the Legal Regulation of Financial Recovery and Bankruptcy, with the fact that I agree with my colleagues, with your remarks, with your positive remarks. The thesis is very qualitative and completed. There is the element of scientific novelty. It is not deprived of the element of scientific novelty. The candidate set bold goals which were successfully achieved. Many problems are solved at high scientific level. A new doctrine, new concept of insolvency was created. Thus, important scientific problem was solved. The author's conclusions are very interesting. They can become the basis for further scientific research, and I agree with all positive conclusions and with the evaluation which was given. I am not going to repeat above mentioned. As for the negative moments, there are no negative moments or drawbacks. There are some moments of discussional character. They are connected with additional argumentation and the position of the authors, in particular the conclusion about insolvency. Only those citizens who can't pay, they should be punished. Then, controversial conclusion about, despite competitive situation, pre-court procedures. Then in some parts of the thesis, the acknowledgement of the citizens as unable to pay. How does this conclusion correlate with the concept of the new start, in particular the liberation of debts? And one more remark. The conclusion in the context of correlation of the application of the concept of the prevention of the debt and the concept of restructuring on the debt. There is a question: can the restructuring of the debt allowed if the debt consumer could not use the prevention of the debt be qualified as a form of liability of the debtor, and what are the consequences in this situation when the these are not drawbacks or remarks, these are discussional moments. The work conforms with the requirements, and our candidate deserves the doctoral degree. And as a chairman, I want to have the floor and read out my review. The thesis of Koraev Konstantin Borisovich. I want to say my review is positive. Topicality, scientific novelty, and the provisions for the defense are reasoned, explained, and they proved not only by the literary sources studied, the judicial practice in courts of arbitration. Some discussional moments I would like to draw your attention to. The Institute of Insolvency is a new institute of civil law in the view of our author. In this case, how can a sub-institute of financial revival, recovery and Institute of Competition can be viewed? And what is their character? The second question, the conclusion about the fact that insolvency comes from the impossibility to or failure to express entrepreneurial activity. The category of insolvency is connected with a widespread commercial system is not enough for the conclusion that insolvency is connected with entrepreneurial activity. In this case, what can we do with non-commercial organizations when they can't pay? Is the category of insolvency or non-payment should be attributed to them. The method of the Institute of Insolvency should be considered on pages 64 and 62. The relationships of insolvency are mentioned, the right of insolvency, what do I understand by that, and what is the content of legal relationships of insolvency. Then the author states that while regulating legal relationships under the situation of insolvency, the the method of mixed legal regulation is used. What do you understand by that? And the final question, from the point of view how which measures could be offered for the elimination of unable to pay citizens. And as for the prevention of the debt, this question is not actual now because you have answered it during your report. And my conclusion is that the thesis of Koraev, Konstantin, Borisovich, and scientific and qualified work, the scientific problem of legal regulation of financial recovery, it is of important social, economic, and household importance. The thesis of Mr. Koraev conforms with the main requirements stated by the Order on Procedure of Awarding Academic Degrees at St. Petersburg State University, and our candidate Koraev Konstantin Borisovich deserves the degree of the Doctor of Law on specialty 120003. Thank you very much. And now I want to give the floor to our candidate Konstantin Borisovich. You have no more than 15 minutes. Distinguished Chairman, distinguished board members, before I switch to the answers to your remarks and questions, I would like to express my gratitude for your review, for the attention to my work. My answers, I would like to start my answers with the answer to the remarks and questions to the chairman of the Thesis Council, Olga Alexandra Makarova. Regarding the first question, I would like to note that the sub-institutes of financial rehabilitation and competition law should be considered as structural elements of the insolvency institution. In this case, in the dissertation, the concept of institution of competition law is used. However, this is done until we conclude that the concept of institution of competition law is incorrectly used due to the fact that at the moment it is more correct to qualify competition law as a sub-institute. Regarding the second remark, it should be clarified that the thesis concludes that the emergence of the category of insolvency is associated not with the development of trade, but with such a phenomenon as a capital advance, temporary investment of money in circulation for the purpose of their return extraction in an increased amount. In addition, the thesis concludes that despite the fact that non-payment is characteristic of consumer credit, the category of insolvency should be used for the purpose of legal regulation, since from a practical point of view, it seems more convenient compared to the category of non-payment. In this regard, in case of insolvency of non-profit organizations carrying out activities that generate income, it is necessary to apply the category of insolvency. With regard to the content of the concepts of insolvency relations, insolvency legal relations, and insolvency legal relation content, in the dissertation they are considered in their traditional sense, namely insolvency relations are actual social relations arising from a person's failure to fulfill monetary obligations. Legal relations of insolvency, these are public relations regulated by the rules of law arising from the inability of a person to fulfill monetary obligations. Regarding the concept of mixed method of regulation, I would like to note it is not commonly used and is used for the purpose of dissertation research to indicate a situation where the legislator regulates relations that are unique in the nature, using private and public law methods depending on type of the subject of law, who are on the side of the creditors of the insolvent debtor. In particular, in relation to public debt, the legislator uses public law methods. In relation to civil debt, private law methods, despite the fact that the collection of these types of debts and the conditions of insolvency of the debtor is carried out in the framework of relations that are unified in nature. With regard to the legal mechanism for the temporary elimination of an insolvent citizen from the sphere of consumption of a bank loan, it should be noted that it is identical to the legal mechanism for the temporary elimination that is used in relation to individual entrepreneurs. And now my answers to the remark of Professor Viktor Sergeyevich Kamenkov. As for the comprehensive legal regulation on insolvency relations, here, first of all, it is necessary to identify two fundamental theoretical points. Firstly, insolvency relations consist of material and procedural ones. When it comes to legal relations of insolvency as a civil law, of course, we are talking about substantive legal relations. Secondly, when conducting a dissertation research, we adhered to a theoretical concept that the law is not complex, but the legislation. The dissertation concludes that from the moment of the emergence of legal relations of insolvency, they are transformed into civil law relations regardless of what branches of law they arose from, since the nature of these relations is civil law. Therefore, when they are regulated, civil law regulation methods are applicable only. Here, I would also like to respond to the remark of Doctor of Law, Professor Valery Alexandrovich Semyousov, that the institution of insolvency should be considered as an institution of business law. It seems that with the adoption of the rules governing consumer insolvency, the attribution of the entire institution of insolvency to the field of business law is not possible. With regard to the identification of deficiencies in the application of the concept of debt restructuring and the lack of proposals for improving legislation, the main proposal that is being made to improve legislation in the dissertation involves the use of the concept of debt prevention. As for the fate of the head of the debtor who obstructs the manager in the context of the proposal on the inadmissibility of eliminating the insolvent debtor from managing his property, I would like to clarify the following. First, it's necessary to distinguish between such entities as founders of the debtor and the head of the debtor. When it comes to the inadmissibility of eliminating the debtor from the management of his property, it means the inadmissibility of the deprivation of this right of the founders. They should have the right to appoint a leader. In this case, the unlawful behavior of the leader should not entail a loss in the rights of another subject of law, namely the founder. In such a situation, the subject of responsibility should be the person who commits an unlawful act, the leader himself. In this case, the predominant type of such responsibility should be administrative responsibility, which also allows for disqualification. Answers to Petrov Dmitry Anatolyevich. Regarding the correlation of the concepts of objective bankruptcy and insolvency, it should be noted that the emergence of the concept of objective bankruptcy is more likely due to law enforcement practice than to doctrinal research, since it became widespread after the adoption of the decree of Plenum of the Supreme Court of the Russian Federation from the 21st of December 2017, number 53, on some issues related to holding persons controlling a debtor liable in bankruptcy. From the content of the above mentioned, it follows that the concept of objective bankruptcy formulated by judicial practice is essentially nothing more than the concept of non-payment long existed in the doctrine. As for the universality of the definition of insolvency and its staging, we believe that it meets the requirements and can be used in the regulation of issues related to holding persons controlling a debtor liable for bankruptcy. Speaking about the fate of the monitoring procedure, it certainly cannot be attributed to either restoration or liquidation procedures. The observation procedure is a neutral procedure, the appearance of which both in Russia and in some other countries is connected first of all with the fact that the new norms of financial recovery were developed in the framework of bankruptcy relations, which ultimately led to competition, new rules, and traditional rules of competition law. One of the mechanisms for resolving such competition was the neutral procedure, the certification of which made a choice between saving the debtor or liquidating it. If in practice the conclusion made in the dissertation is realized that all stages of relative and absolute insolvency one should give priority to sub-institute of financial recovery, and at this stage of insolvency the sub-institute of competition law, then the problem of competition between the norms of financial recovery and competition law will be eliminated. In such a situation, the observation procedure becomes meaningless, and therefore the problem of its qualification as a restoration or liquidation is solved. As for question 3, it is the remark is also contained in the remark review of Telukina Marina Viktorovna. As for the remark of the necessity to apply bankruptcy legislation in relation to those citizens who have credit and loan agreements, I would like to say the following. Firstly, when it comes to the application of bankruptcy legislation in relation to a bank loan, it is understood that bankruptcy cases can only be initiated if there is a debt under a loan or loan agreement concluded with credit institutions. However, upon certification of such a case, all citizen debts, both bank and non-bank, are subject to repayment, with the exception of those that are inseparable from the person of the debtor. Secondly, the insolvency law is aimed primarily at protecting public credit. Protecting this loan, he has to come into conflict with one of the fundamental principles of the civil law, the principle of proper performance of obligations, since one of the consequences of a bankruptcy case is repayment of debtor debt. Under these circumstances, it should be borne in mind that the application of insolvency legislation in order to protect a particular type of public loan should be carried out as an exceptional measure, in which, by sacrificing the principle of the proper fulfillment of the obligation, we should get more benefits than maintaining this principle. According to websites of the Russian newspaper, the total debt of citizens on communal debts is 750 billion rubles. According to newspapers' website, the debts of citizens to banks is about 16 trillion rubles. At the same time, the nominal GDP volume in 2018 amounted to 103 trillion rubles. Statistics on the size of debts under contracts of guarantee and other debts of citizens are not kept. However, it seems that it is unlikely to exceed even the size of public debts of citizens. Under these circumstances, the dissertation concludes that the application of bankruptcy law should only be used to protect bank consumer credits, since in this case the practical effect of applying the mechanism will not be much greater than observing the principle of proper performance of obligations. As for utility and other types of non-bank loans, their significant share indicates that they do not need protection through such as exclusive legal mechanism as bankruptcy, and therefore in this area it is better to give priority to principle of proper performance and obligations. In addition, the practice of applying legislation on consumer bankruptcy has shown that the bulk of bankruptcy cases are cases arising from the inability to fulfill citizens' obligations from a loan agreement. And now my answers to Alexei Ivanovich Kurbatov, Doctor of Law. As for the category of bankruptcy, in the dissertation it was used as a synonym for the category of insolvency, which in turn is one of the stages of insolvency. As for remark 2, as a result of this study, as indicated earlier, it was concluded that the doctrinal content of the concept of insolvency is primarily associated with such a thing as advanced payment. Prior to the emergence of capitalist relations, the boundary between the types of activities that were based on advance payment passed between trade and other types of activity. For this version, it was customary to differentiate insolvency law into commercial and non-commercial. With the emergence of capitalist relations, this border shifted and began to pass between production activity and all other types of detail. Thus, a significant change in the property relations acting as subject of bankruptcy law regulation ultimately affected the nature of the rules that governed them. In other words, these concepts are not independent in relation to each other, but are the results of the evolution of insolvency law. As for remark 3, I would like to note that in the cited place of the dissertation, we are talking about exemption as an actual action, not associated with the alienation of property. Therefore, with such a seizure of property, Alexei Yanovich quite rightly notes that there is no termination of the right of ownership, but its limitation. As for the remark concerning the theory of interest, included in Part 3 of Article 55 on the Constitution of the Russian Federation, I would like to note that the conclusion about the restriction of the rights of a person in its own interests was based on a doctrinal idea of a theory of interests, the course of commercial law, which of course is much broader in content theory, that has found its legislative recognition in the Constitution of the Russian Federation. And how can we solve the situation where there are counter agents of the debtor, and in such situation other legal instruments should be applied? In particular, these may be instruments such as the purchase of an enterprise or shares of an insolvent legal entity in order to realize its interest in maintaining a legal entity or property complex. Then I would like to answer the remarks of Telukina Marina Viktorovna. As for the possibility of terminating the powers of the head of the debtor, I would like to note that the possibility of terminating them within the framework of restoration procedures is unacceptable not only from a legal point of view. This first of all does not correspond to the nature of regulated relations. In order to put capital into action for the owner, he must be sure that having completed this work, the money will return to him. Under these circumstances, in order for the insolvent debtor to take action to restore his solvency, he must be sure that having performed the indicated actions, the additionally raised money will be returned to him. Such confidence can exist only if the debtor does not withdraw from the management of his property, which in turn, from the legal point of view, should exclude the termination of powers of the head of the debtor. The Sub-Institute of Competition Law, in the entire history of its development, has never pursued the goal of freeing the debtor from debt. On the contrary, the emergence and development of this institution was due to the need to release public credit from debtors who were unable to fulfill their obligations by eliminating them from these relations. In this regard, it is thought that the legal regulation of insolvency of a citizen consumer, which does not eliminate an insolvent person from the system of credit relations. It should be especially noted that the elimination of an insolvent debtor from the sphere of credit relations as a goal of competition law does not exclude the idea of a fair and proportionate satisfaction of the creditor's claim, including repayment, which acts only as one of the main tasks of bankruptcy proceeding. Regarding the question of whether debt restructuring can be qualified as a form of responsibility for not using debt prevention, it should be answered that it cannot be. The dissertation research concludes that the use of restorative procedures should act as the subjective right of the debtor. Under these circumstances, debt restructuring and prevention, being different legal mechanisms for restoring a debtor's solvency, should qualify as his subjective right, which he must exercise in accordance with the general principle of civil law. Then I would like to pay attention to the questions and remarks of board member, Doctor of Law, Professor Luisa Timbulatovna Koraeva. Regarding, as for the accounting for changes in the dissertation of the bankruptcy law that entered into force on the 3rd of July 2019, it should be noted that such changes were not taken into account in the thesis due to the fact that the text of the dissertation was put on the dissertation council earlier than the specified date. Despite this, an analysis of these changes gives reason to argue that they do not significantly affect the reliability of the conclusions and proposals made in the dissertation. As for the question why the duties, prohibitions, and restrictions of the debtors caused by the actions of persons controlling it are not considered, I would like to know that this issue is so private that its study would not have any significance for disclosing the topic dissertation research. And now the answers to the questions of Professor Papandopoulou Vladimir Fedorovich. As for the question of correlation of the concepts of debt prevention and debt restructuring, first of all, they're completely different. On the other hand, the main idea of the concept of debt prevention is to prevent the emergence of areas of its substantial growth, while the implementation of the concept of debt restructuring is not conceivable without arrears. And on the other hand, it is not prerequisite for the implementation of debt prevention the presence of any income from insolvent debtor, while it is prerequisite for the implementation of debt restructuring of the presence of income from a citizen. This is reflected in paragraph 1 of Article 223.13 of the bankruptcy law. As for the question of salary in the conditions of temporary loss of the source of income, a citizen becomes insolvent. Moreover, if the amount of overdue debt for the period of loss of income increases significantly, then the restoration of income in the previous amount will deprive him from the ability to fulfill obligations. It is precisely in the period of lack of income that it is necessary to prevent the growth of overdue debts in order to ensure the preservation of solvency when restoring the source of income. Regarding the question of why the concept of debt prevention is limited only by consumer insolvency but not entrepreneurial insolvency, it should be answered that this is due to the fact that in conditions of entrepreneurial insolvency, the size is not decisive. It should be taken into account that the main income of the entrepreneur is not wages but produced and sold goods, works and services. It should be especially emphasized that the above mentioned does not mean that the legal mechanisms for restoring entrepreneurial insolvency cannot be applied in the context of anticipating insolvency in order to prevent debt. Of course, this is possible and desirable. It is important only to consider that for the business sector, this is not significant in contrast to the consumer sector. I have finished. Thank you very much for your attention. Please be seated. Do you have non-board members, do you have any questions strictly according to the thesis? No applicants, no volunteers. I raise the question of awarding or not awarding scientific degree. I declare a 5-minute break, and I ask you to turn off the sound of the broadcast of the meeting. Guests, please leave the hall. I will invite you when our consultation meeting is over. Switch on the sound of the meeting's broadcast, and the conclusive minutes of the dissertational council's meeting are coming. I raise the question of awarding an academic degree to an open roll call. I remind you that the decision of the dissertation council on the issue of the awarding the degree is considered positive if more than half of it voted for, but not less than 3 members of the dissertational council who participated in the meeting, in accordance with paragraph 23 of the procedure for awarding academic degrees at St. Petersburg State University. Board member Petrov Dmitry Anatolyevich, I am for the degree of the Doctor of Legal Sciences on specialty 120003. Board member Koraeva Luisa Timbalatovna, I agree with my colleague and I'm for the awarding of the degree. Board member Kurbatov Alexey Yanovich, I'm for the awarding degree of the Doctor of Law to Koraev. Board member Kamenkov Viktor Sergeyevich, and I have got the same opinion. Tilyukina Maria Viktorovna, board member, I'm for the degree. Thank you very much. But as Marina Viktorovna Tilyukina takes part in the meeting of our board, not from the very beginning, unfortunately, while counting the votes of the board members, we won't take into account her voice. As for my opinion, I'm for the degree. Thus, counting of votes. I declare that announce that out of 5 members of the council participating in the meeting, 5 voted for, no one voted against, and no one abstained from vote. Thus, decision on awarding the academic degree of the Doctor of Legal Sciences on specialty 12/0003 Civil Law, Business Law, Family Law, Private International Law to Koraev Konstantin Borisovich is accepted. And now I would like to give the floor to our candidate for his final word. Thank you very much. I would like to express my gratitude to the chairman of the council, Doctor of Law, Olga Alexandrovna Makarova, and all board members for the opportunity to defend the thesis at the university and for the interest and attention you showed to my work. Also, I would like to thank scholars who made remarks concerning my thesis, and separate words of gratitude I would like to express for support, help, advice to my to Doctor of Law, Professor, Head of the Department of Business Law of St. Petersburg State University, Vladimir Fedorovich Papandopoulos. Thank you very much. And in conclusion, I would like to express my gratitude to those who helped who helped today meetings, who helped the work of today's meetings, and to our interpreters. Thank you very much. Please switch off the live broadcast of the meeting.